So I wanted to welcome everybody to the 11th webinar of 2014. My name is John Haber. I'm the Field Services Director for the California Preservation Foundation. We encourage you to become a member of CPF and enjoy the benefits and educational discounts. Information on membership can be found on our website at californiapreservation.org. The California Preservation Foundation is a membership-based, not-for-profit organization whose mission is to provide statewide leadership in education and advocacy to ensure protection of historic resources in California. The format for today's webinar will consist of a presentation of approximately 60 to 75 minutes, shared between two experienced attorneys with the knowledge of CEQA case law. We will close with a 15-minute question and answer period. On the bottom left-hand side of your screen is a Q&A box. If you have a question at any time during the presentation, you may type it in the box, and we will hold the question until it can be addressed by a speaker. Right above the Q&A box is also a chat box. You may also ask a question using the chat box. Any questions or queries or comments typed in the chat box will be visible to all participants. If you are attached to a microphone, you should grant Adobe Connect voice access to your microphone when asked to do so. Your voice will be muted during most of the presentation, but you may raise your hand by clicking on the hand symbol at the top of your screen. Once your hand is raised, we will grant you voice access at an appropriate time in the presentation. This will allow you to have a short dialogue with the speakers or ask a question in person. If for some reason your sound does not work, you will need to type in your question or response in the chat box. I'm now going to introduce our two speakers today. Attorney Susan Brandt Hawley, UC Davis, 1977, represents public interest preservation groups in CEQA cases statewide from her offices in Sonoma County. Her environmental cases have contributed to President in the Court of Appeal and the California Supreme Court. She received the 2001 California Lawyer of the Year Award in Environmental Law from California Lawyer, and has been named repeatedly to the Daily Journal's list of California top women litigators. She is a member of the California Academy of Appellate Lawyers. Deborah Rosenthal devotes her practice to land use and environmental law and litigation with an emphasis on historic preservation. She has a master's in regional and city planning from the University of Oklahoma, where she serves on the Board of Visitors, and a JD from Yale Law School. She is a member of the American Institute of Certified Planners. She has been listed as a California super lawyer in land use and zoning annually since 2005. She primarily represents landowners in complex permitting programs for large private development projects, requiring coordinated approvals at the local, state, and federal levels. On historic preservation matters, she has represented private developers, public agencies, and advocacy groups. Prior to moving to California, she was the executive director of the statewide nonprofit advocacy group Landmarks Preservation Council of Illinois. What I'm going to do right now is briefly mute everybody in the room. Don't be alarmed if your phone tells you you've been muted. If at any time you'd like to ask a question, to unmute yourself, you would press *6. 1 second here. Okay, so without further ado, we will now begin the presentation.
Thank you, John. This is Deborah, and I'd like to start our presentation with the start or the first question that comes up in trying to decide how historic preservation and CEQA work together. As most of our attendees know, CEQA does not apply to all government decisions. It is intended as an informational statute, and it only applies to government decisions that involve a government undertaking or an approval of a project where the decision requires the exercise of discretion or judgment. I like to think of it as situations where the public agency can say yes, no, or maybe, especially maybe. The ability to impose conditions on an approval is very much a hallmark of a discretionary action that triggers CEQA, so it becomes a project under CEQA. This case, this issue was addressed in Prentice against the City of South Pasadena a little more than 20 years ago. And what Prentice held was that in a situation where there was a landmark house and someone was coming in with a landmark house, the issue wasn't whether the building was historic. The issue was whether the city required, had discretion to say no to a building permit. And this comes up frequently in historic preservation because a lot of cities designate their designate landmarks and historic districts, but then they don't link that to their building permit or demolition permit process. So there's judgment in deciding whether a building is historic, but no discretion in deciding whether someone can have a demolition permit. And I used to get a lot of phone calls from concerned community groups who wanted to know what they could do when a demolition permit was asked for a designated landmark. And they thought CEQA would help them, but CEQA actually needs to have a discretionary decision. And so that becomes very important. In the Friends of the Juana Briones house against the city of Palo Alto in 2010, there was a building that was a landmark and it had the Mills Act, but the city's ordinance, local ordinance, according to the court, did not give the city discretion to say yes, no, or maybe. The only discretion the city had under their ordinance was to say wait 6 months or wait a year. And the court in that case held that the discretion to say wait was not the kind of discretion that gave them the ability to condition a project or shape the project. So both the Prentice and the Juana Briones case stand for the proposition that it is very important to have a local preservation ordinance that gives discretion when you have either an historic building or a potentially historic building. So I encourage everyone to go back and check their local ordinances to see what kind of discretion it gives in those situations. Now, it isn't always easy to tell when a decision on a demolition permit and a building permit is discretionary. And that came up in the San Diego Trust and Savings Bank against Friends of Gill case a long time ago, really less than 10 years after CEQA was adopted. And in that case, there was an EIR prepared, and it wasn't challenged, but it didn't really address the demolition questions properly. And one of the questions that went to the court was an ordinance that I would call a delay plus ordinance. San Diego had one at the time. Los Angeles has one, where it says you can't get your demolition permits for 6 months, and during that 6 months, we're going to try and talk to you. We're going to try and come up with alternatives. Maybe we'll buy the property. And so the court in Friends of Gill found that that delay plus made it a discretionary demolition decision in San Diego. But it is not a situation where it's a good idea to rely on a court finding that the delay plus is enough. It's obviously better to have an ordinance that does that heavy lifting and makes it clear that it's subject to CEQA.
And Deborah,
Now,
I'd like to just jump in here. This is Susan. Hello, everyone. And Deborah and I had talked about joining in on these various topics, and I just wanted to point out that the Friends of Juana Briones house, the Palo Alto ordinance in that case also, as Deborah mentioned, had a delay component that prior to issuing the demolition permit, had to go, their required review and delay by the local preservation commission, very similar to the Friends of Gill case. And so these two cases, I think many people believe, I certainly do, are in direct conflict. So sometimes courts have found that a delay, because the reason for delay is to try to find a solution and avoid demolition, sometimes delay is considered enough discretion to trigger CEQA, as in Friends of Gill, and sometimes not, as in Friends of Juana Briones.
I think that's right, and the court in the Juana Briones case went out of its way to say this is a delay ordinance, but not a delay plus ordinance, which would be which would have taken it into Friends of Gill, and so that's why it's better not to have to rely on a court to interpret the ordinance. It's better to have the public agency say, this is what we intend by our delay ordinance or our evaluation ordinance. Now, looking at what a project is, it's also important to know when a project is created for the purposes of CEQA, because a lot of public decisions involve
I don't know what's going on.
a lot of public decisions involve multiple decisions that, okay, we're going to slide number 4, pre-commitment to the project. And they involve multiple decisions that lead up to a final approval. And CEQA says that the environmental analysis needs to be done as early as possible in the project, once you really know what your project is going to be, and critically, before the public agency gives up its right to discretion. So it's called pre-commitment to the project, and what the cases have said is that you look at a course of conduct, and when a public agency has committed itself to proceed with the project, that at that point, before they make that commitment, they have to do the environmental review. And the court doesn't just look at whether there's a legal commitment, but whether there's a practical commitment. The leading case in that case is issue is from 2008, Save Tara, and we have a picture of Tara against the city of West Hollywood, where the city, the owner of Tara had died and left it to the public agency, and they were going to redevelop the property, including both preservation of a portion of the building and some new development. And the city gave an option to purchase. They agreed to give $1.5 million subsidy. They agreed to give an unconditional $1 million loan to the developer, and they got a $4.2 million grant to redevelop the property. And they did all of that without doing any environmental. Then when it was time to actually sign the contracts, the city said, did the EIR and said, surprise, surprise, we think this is an excellent, well-mitigated project. They were sued, and the court said, no,
They were sued before the EIR process was complete, though.
Okay.
In the middle of it, yeah.
And the court decided that the city had really committed itself, and that EIR had to be voided, and they needed to go back and reconsider the project without that pre-commitment. Now, the question of pre-commitment was also came up.
Deborah, I'd just like to say a little bit about Save Terra as well, because there were some really extreme facts in that case where the developer in the city had started to relocate the tenants from the property, before they had approved it or done environmental review. And in cases, all the cases that are coming up next that Deborah will talk about, and there are others as well, they all rely on this Supreme Court case. This is the case that lays out the rule, and then the other cases talk about the facts. But you're never going to see a case where they relocate tenants before they actually approve the project. So the rule, the Supreme Court made clear there's no bright line rule here about when proper planning goes over the line and becomes pre-commitment. That takes a look at that's a question of law based on the facts of every case, and the question is whether the actions of the agency create a bureaucratic and financial momentum that as a practical matter means they've approved the project. And anyway, I just wanted to stress that what I've heard in a lot of other situations is like, well, this isn't like Save Terra because there's no relocation of tenants or the egregious things that happened there. And of course, now that we all know about Save Terra, no one's going to do that. But we have seen, and in fact, I've been involved in a case in San Diego where pre-commitment was found in a project involving the Balboa Park there, where, of course, there wasn't a relocation of tenants. And it can prevent going too far along the road before you do CEQA. Thanks, Deborah.
Yes, what the courts all say is that you don't foreclose the ability to select other alternatives than have been proposed. And in Save Terra, the court was, I think, offended by how far they'd gone and what they'd done in terms of the commitment. In the other two cases, which did not involve historic buildings, the courts have been more willing to find that there was not pre-commitment, either in terms of that momentum that Susan mentioned, or legal pre-commitment. Cedar Fair was one where they had done a very detailed preliminary agreement, but they were still negotiating the final agreement. And the court said, well, it may be unlikely, but no project is still possible under these situations. And City of Irvine against the City of Orange.
I'd like to say something about Cedar Fair too, which is that in that case, it was it was the Great America Amusement Park fighting with the football league that is now, I think that's already built, is about built now, the Santa Clara Stadium for the 49ers. It was two big commercial entities fighting over a parking lot. There was really no pretense of an environmental problem. It was commercial entities, and that does, I think, play into what courts do when they see what's going on, whether it's technically related to the legal issue. And all of the cases make clear that the fact that there's a development agreement or a term sheet doesn't necessarily, that isn't in the term sheet in the Cedar Fair, doesn't mean that every case with a term sheet or a development agreement is or is not pre-commitment. Again, you have to look at the whole circumstances. But it seemed in Cedar Fair, the court said it was a very close case, and in fact, it's really extreme facts to say no pre-commitment, but they were not sympathetic plaintiffs.
Although development agreements are technically subject to CEQA, and they are considered at least commitment if it's a statutory development agreement. There may have been some redevelopment agreements that were not considered that, but a development agreement that affects historic buildings would be highly unlikely to be to avoid full CEQA review, simply because the public agency is committing to certain activities when there's a development agreement. The City of Orange against the City of Irvine against the City of Orange case, again, not an historic preservation case, but I think may be very important for some of the public entity listeners. That was an application for state funding for a jail, and there was a lawsuit on the application for state funding, essentially saying that the that the state funding application was a commitment. And the court said, as a practical matter, you really need to know whether you're going to get the state funding before you can, before it makes sense to spend the money on environmental documentation. So they made an analysis of what kind of commitment is involved in state funding, and decided that in that particular situation, even though obviously the City of Orange was going to be leaning towards proceeding if they had an extra, a lot of extra money approved for the jail, it was not the kind of commitment that required them to do an EIR. Now, on the what is a project? The project as a whole must be considered. This is can be very important under cases that involve the same kind of facts as Friends of the Orinda Theater. It's an old case from 1986, and it held that the proposed demolition of the theater was required for a much larger project, and that therefore demolition was the first phase of the project. And in that situation, even though the county arguably had a non-discretionary demolition permit, because it was part of a much larger approval, the county actually imposed conditions on the demolition permit. And so it was a situation where they said maybe, and that ability to say maybe to the demolition and impose conditions made it part of a larger discretionary project. And I think that's a situation that certainly in cases where you have a public project or a project where no demolition can occur until the project is approved, a replacement project, you can call it, it can be considered a discretionary project, and the demolition then was subject to CEQA, and alternatives needed to be investigated.
And I think this is, did you switch it ahead there? Or, I just want to talk
yes.
a little bit. If you're talking about the Orinda Theater case, I just think it comes up all the time that demolitions are proposed, and especially, project applicants can be pretty sophisticated about this and propose to demolish an historic resource saying they don't have another plan for the property. But the reality is, we all know that people don't demolish buildings usually without a reason that they want to do something else with the property. And of course, once the building is gone, you don't have the opportunity to consider whether adaptive reuse could accomplish most of the project objectives. So it's something to really watch out for, that if you happen to be in an area that has ministerial demolition permits, and whether or not the new project has yet been applied for, if in fact this is, as Deborah said, and I won't go on and on about it, but I just think it's really important to know that CEQA requires that environmental review cover the whole of the action, as it's stated here, and not each individual permit. So segmentation of the demolition from the actual project that it's probably related to is something to watch out for, and there's no requirement that there actually be an application for that new project. Sometimes it gets pretty difficult to tie them together, but that's the key to avoiding demolition as a ministerial action when there's a permit that's going to be required for the next action. We didn't win that argument in Friends of Juan Briones' house, but many times one can. Thanks, Deborah.
Okay, I think we're now going to talk a bit about once it's clear that there is a project, it's a discretionary decision, and they're making the decision at the right time. There is a question about whether CEQA is going to apply anyway. And Susan, did you want to talk about concerned Dublin citizens?
Well, not really specifically. If you want to talk about that one in general, there are two types of exemptions from CEQA. Once you figure that you have a project, then you have to see if there's a statutory or a categorical exemption. And concerned Dublin citizens, I'm trying to remember, I should have looked more at this one, Deborah. Is that a categorical or statutory, the consistent
It was
with a
a
specific plan?
statutory, it was a statutory exemption for a situation where the city had already approved the specific plan, and I believe the statutory exemption was for residential development consistent with the specific plan. And the court held that if there was no change in the project from the specific plan, it was going to be, it was exempt under the statutory exemption.
Right. And this wasn't, as I recall, it's not a historic preservation case. It is relevant because, of course, it could apply. But unless you have a specific plan that dealt with an historic resource and the demolition of that resource, it would be unlikely you could use this statutory exemption.
But one of the issues would be if you had a specific plan which was not challenged, and perhaps it dealt with an historic resource in a way that you didn't, that was not acceptable to the community. The court did say that that you don't use the typical kind of exceptions to the exemption that I know you're going to talk about on Valley Advocates for statutory exemptions. So for an exemption that the legislature has said this is exempt, you don't get exceptions to that the way you do with categorical exemptions, where the legislature said make up a list of things that don't typically have environmental impacts.
Okay.
And
well, but if
that's the categorical.
I still think it's unusual to find a specific, if there was a specific plan that dealt with demolition of historic resources, hopefully while that specific plan was being approved, that would have been vetted. So it's true that if there was a specific requirement or allowance for demolition of historic buildings in a specific plan, that should be dealt with when the specific plan's approved. But if you can show additional information or that something wasn't considered specifically in the plans, often those plans have kind of general language about what to do if you have historic resources involved. And anyway, I just think it's unlikely it could happen, but this kind of exemption isn't one that is easy to use to demolish historic buildings that haven't been considered for rehabilitation. But anyway, it is a general case out there. Then, as Deborah started to say, there's statutory exemptions are absolute. These are things the legislature have decided, types of projects that are exempt from CEQA regardless of impacts. There's a second big category of exemptions that are categorical exemptions. And basically, there are a lot of types of projects that are so simple and so obviously will not cause environmental impacts that they are put into classes and categories, and most of you know this, that can avoid environmental review because it's a waste of time. And such things as single-family homes, for example, and some simple infill development. So that a categorical exemption can be claimed for projects that fit into one of 33 classes that have been created by the Secretary of Resources. But unlike statutory exemptions, which are absolute, categorical exemptions are basically rebuttable presumptions, and there's various things that take a project out of a categorical exemption, including if it will cause a substantial adverse impact to an historic resource. So that does not qualify for a categorical exemption, period. There are other exceptions to exemptions, which include when the cumulative impact of similar projects may cause a significant impact, or where there's a reasonable possibility of a significant impact due to unusual circumstances. But bottom line, if in fact there's going to be a significant impact, a categorical exemption should not apply. Now in Valley Advocates, that was an infill exemption. I don't think it was single family, although I could be remembering
It was
wrong.
infill and additions. It was not single family, but it seemed to me to apply to the same theory apply. As a matter of fact, the exception that you talked about is one of the ways that individual historic buildings that require discretionary building permits get into the CEQA process, because it's typical for cities to think that single-family homes or individual very small structures are exempt. And sometimes there needs to be a reminder that they're not exempt if they're going to have these particular kinds of impacts.
And in this
But
case,
Valley Advocates was an infill project with two large residential flats.
right, the cutting flats, and those, the court held that the city, even though they had been found, were not in a local register, the city, the case actually was remanded back to the city by the Court of Appeal that said the city had to take a look at whether, in fact, they were historic resources before they could go ahead with contending that they were exempt under a categorical exemption. I'm trying to go to the next slide. There it is. This case, the Berkeley Hillside case, is pending at the California Supreme Court. That picture that you see is a proposed 10,000 square foot, 10-car garage home proposed on a very, whoops, somebody moved it again, maybe me. Trying to get back to the right slide. Anyway, proposed on a very narrow roadway in the Berkeley Hills. And there was a 1917 little craftsman cottage on the property initially, but it was unlisted. And the city approved the demolition of the little cottage and the construction of this 10,000 square foot home, which would be one of the two largest out of 17,000 in Berkeley, primarily based on the categorical exemption for single-family homes. And there was a significant amount of evidence, including a geotechnical expert saying that this, you can see how steep it is. It's on a very steep slope. There was geotechnical expert info that the location was unstable and that there could be geotechnical landslide problems with the construction. There's also right next to the house, there's an elevated concrete roadway that's cracked, and there was a question about all the excavation needed into this hillside for this house could affect this concrete roadway. There wasn't room on the road to, have the trucks come in. It's a really, really narrow road, so they were going to have to do the staging area blocks away to build the project. It's also in an area of Berkeley with all kinds of 1920s and 30s architecturally significant small homes, and there's a general plan designation in that area that the Berkeley, has chosen to create, that all development in this architecturally and historically significant area must be compatible in scale and mass and design. So the city approved the demolition and construction on a categorical exemption. There was a lawsuit by this group, the neighbors and people around Berkeley, that it should have environmental review. The trial court found that there had been evidence, significant evidence, that there were geotechnical problems and inconsistency with the general plan. However, the exception to this categorical exemption that was focused on here is an exception for a situation where there's a reasonable possibility of significant impact due to unusual circumstances. The trial court said, yes, there's significant evidence of environmental problems, but it's not an unusual circumstance. On appeal, the First District Court of Appeals said, no, you don't need to show separately an unusual circumstance, that the way the Public Resources Code is, any project that has a potential significant impact has to have an EIR, and the categorical exemption statute doesn't change that. And the use of the words unusual circumstances in the guidelines doesn't add anything to the statutory authority, and the case is now pending before the Supreme Court is fully briefed. It's been fully briefed for over a year. A lot of people, I need to editorialize a bit, think that this case is a real, a hugely impactful case that's going to change the way categorical exemptions are done, and it really doesn't seem so. It's just the facts of this case, what the cases have said is unusual circumstances, even if you have to look at them, just mean it's not a run-of-the-mill case, and this one has certainly got a lot of facts that do not look like run-of-the-mill.
I think probably the question is whether the Supreme Court will really give guidance on what is meant by unusual circumstances, because I think in almost every situation, opponents of a project think there's something unusual about the project. Now, this case with a 10,000 square foot home, including a 10-car garage, may be clearly unusual, but question of where the line is drawn is
well, I agree.
very
well,
questionable.
Well, I agree.
And the court said any reasonable probability of a significant effect. And that certainly, if the Supreme Court doesn't give guidance on that, it essentially will say categorical exemptions can't be used if you can show there will be a significant effect.
That's right,
so
and that's yes, and that's what CEQA says. There's three statutory sections of the Public Resources Code that say if there is a potential significant impact, you do an EIR. And the section on categorical exemptions just says there's a whole bunch of projects that obviously won't have significant impacts, so don't bother doing environmental review. But yes, if in fact there's a fair argument, this is, I think, what the Public Resources Code says, and the guidelines can't change that. The guidelines can't expand the Public Resources Code. So this quote about unusual circumstances in the guidelines as a requirement here, the guideline, it's just a guideline. It's a rule. It's not a statute. So you have to find the authority in the Public Resources Code, and there's no authority in the Public Resources Code that says categorical exemptions trump the overriding CEQA mandate that when you have a potential significant impact, you do an EIR. And people that are worried about that, it's the same rule as with a negative declaration. All of you on the line probably are aware of the rule that if there's a fair argument of a significant impact, which means, credible evidence, you do an EIR. And despite that, we have 90% of projects going through on neg decs and not EIRs. So it's not that the fair argument standard is, anyway, such a terrible thing. It works fine, and that's what should happen with categorical exemptions. And Deborah, I agree with you that it's really confusing about what is an unusual circumstance, and it'll be a lot simpler when that is not looked at as a separate criterion for finding an exception to an exemption, because it's really confusing about what's unusual and what's not. And the basic point is that if a project is going to have a significant impact, despite being in a categorical exemption class, there must be something unusual about it, because otherwise it should fit into that class and it shouldn't have an impact. Okay,
well, I think that one of the things that is that probably causes some is honored not so much in the practice at local agencies is the idea that if you have a categorical exemption, you apply the categorical exemption. If, on the other hand, you're not eligible for a categorical exemption because you are because it's there's a significant impact, then you either need to have it fully mitigated, or you wind up doing an EIR, and that's just not how it's really been done very much. But I think that so I think people need to keep an eye out for this decision. I get emails from the Supreme Court to tell me when they've made decisions, and I've been looking for this case for a while to give us some ideas about how significant impacts are going to be handled according to the Supreme Court, for categorical exemptions.
Right.
But
Well,
there
there's
is
no argument. Yeah, we haven't had oral argument yet. Hopefully, I mean, I imagine we will have argument this year since it's been fully briefed since April of 2013. So
it's time. So
you should think so.
yes. There is a question about what is a significant adverse impact and how do you know if you have one? And the general rule is that there's a fairly low standard for knowing whether there's a significant impact. That if there's a fair argument, if there's no argument that there are going to be significant adverse impacts, you can do a negative declaration. If there's a fair argument that there will be significant adverse impact, then the impacts either have to be fully mitigated or an EIR has to be prepared. And the leading case, one of them is the Architectural Heritage Association against County of Monterey, one of Susan's cases. And the way I usually think of fair argument, even though it's somewhat imprecise, is that if you've got scales and there is information showing there could be evidence showing that there could be an impact, and there can be evidence showing that there won't be a significant impact, the court or the city doesn't look at the evidence showing no impact. You really only look at one side of the scale. You can look at whether it's credible evidence or whether it's obvious someone is making something up or it involves aliens and aluminum foil, but you only look at one side to see if you need to go into the EIR process. So it's pretty much any kind of reputable evidence. And in the Monterey case, it involved the 1931 old jail, which had some architectural features, but it got a lot of attention for cultural significance as the place that Cesar Chavez was jailed for 2 weeks in 1970 that jailing played a very important role in the farm worker movement in California. There were other important people jailed there, and the city actually had treated the building through the process as significant, but they historically or architecturally significant, and then they found that any significant impacts would be fully mitigated by documenting the building, and therefore a mitigated negative declaration could be done.
That's not. I'm sorry, but that's not exactly right. There was an initial report that said it was historic, but then the county found it was not an historic building, not just that it was mitigated.
Well, they also
mitigated.
They also required mitigation, and
yes.
And they said that and at some point in the process it was determined eligible, and the court found that
it was
the fair argument
eligible
standard,
after it was after the case was over. It's now a national landmark, but not during the case. While it was on appeal, there was some activity, and the Court of Appeal said you can't count listing that happens after the city.
Right, and so so the Court of Appeal was in a kind of funny situation where there was a building that was obviously important, but they also found that they weren't allowed to consider that importance in the case. And so the court found at least that the fair argument standard applied to, in that case, they found that it applied to whether it was an historic building, whether there was going to be a significant impact from demolition, which seems kind of obvious now, but they also looked at whether the mitigation of documenting the building would be enough, and they found that it would not be enough. So that that case really, I think it's fair to say, took a number of projects that would otherwise have been done on mitigated negative declarations and became evidence for or precedent for requiring an EIR.
Well, I'd like to say also that this is the second case, the League for Protection of Oakland's Architectural Resources versus City of Oakland case, which is also somewhere in the PowerPoint, involving the Montgomery Ward building before, it's demolished now in Oakland, all said the same thing, that the fair argument standard applies to determination of treating an unlisted historic building as historic. In my opinion, handling both of those cases, they are consistent.
Although the Montgomery Ward case would fall under the category of presumptive historic resources under the CEQA guidelines because it was on a survey.
But the city found it wasn't historic. The city made a finding that it was not historic. So
well,
they
that's also an interesting issue about making findings that that I think that courts are not very as sympathetic to a city that changes course in the middle and treats a building as historic and then decides it's not historic when they see a project that they would like to approve. And one of the things I found particularly interesting about the Valley Advocates case was that it held that even if there's been a decision not to list a building under local resources, and even if it's not on the register, you take another look at that issue when you're doing an EIR. So at some level, the question of whether a building qualifies as an historic resource gets done over, needs to be looked at in the EIR or in the negative declaration context. So that question of changing its mind and treating a building as historic and then not treating it as historic is courts are, I think, not willing to give as much discretion as they say they are willing to give. The substantial evidence test in the EIR, again, I think of that in terms of scales. And in that case, the court does look at both sides of the scales. And it will typically look at whether there is, it will typically then look at whether there is enough evidence to support the decision that the public agency made. And if there's enough evidence on one side of the scales, even if it's less than the other side, the courts say, they don't always do, but they say that there is substantial evidence to support the public agency decision.
And just to summarize that a little bit, and I know we have to move on, but there are different questions, of course, when the question is, do you need to prepare an EIR? And as opposed to, once you have an EIR, what are the significant project impacts? So in step one, do you need an EIR? The fair argument standard applies, I think, clearly under the case law with the exception of the Valley Advocates case, that a fair argument of historic status of an unlisted resource triggers an EIR. When you get to the EIR phase, which is what this slide that's up now is saying, once you're in the EIR process, then it's a substantial evidence test. If you have disputing experts, expert dispute about historic status, the agency gets to pick, but not when the question is, should we do an EIR? But we should move on here, I think.
And if you've already done an EIR and you have, the question is whether you need to do additional environmental documentation, that also the court held in the megaplex-free Alameda case that you did look at substantial evidence for that, and there also was new information submitted, and the court said that that new information had to have been unavailable, not just not submitted, but unavailable at the time of the original decision. So we've talked about whether there's going to be a substantial impact on a historic resource, and we started some discussion on what is an historic resource. And Susan, I know you have some things to say about that.
Well, no, I think I already said them, actually. I was maybe ahead, but basically the old jail, the main criterion for historic significance was the event of the Cesar Chavez incarceration during the lettuce boycott. And basically the court relied on the fair argument standard and explained there's a very comprehensive discussion in this case about that. In the, I guess we don't have more on that. In the League for Protection case, actually, we had argued that drawing a chalk mark around a dead body is not mitigation. In this case, the architectural heritage case, they actually did put that in the decision in terms of mitigation. I guess we get to that later, though. This is just whether it's historic. And I guess moving on to this next slide, the Cutting Flats case, the Valley Advocates, it's a categorical exemption case. In dicta, in extra, for those of you who aren't lawyers, when a court opinion talks about an issue that is not directly needed to decide the case that it's handling, it's called dicta, which is not as strong as a holding that directly relates to the facts before it. In Valley Advocates, CADX case, the Court of Appeals said that an unlisted property, the fair argument standard does not apply to deciding whether you have an historic resource for an unlisted resource. And that is inconsistent with architectural, whatever it's called, Architectural Heritage Association and League for Protection. It's dicta, and I don't think we should spend a lot of time on it. Deborah and I completely disagree, I think, on which case maybe controls or what, in fact, what should happen here. But it doesn't make sense that in every single situation that a negative declaration is, the standard is if there's a fair argument, why for some reason that shouldn't apply to whether a project may have a significant impact on a historic resource when there's a question as to whether the resource is historic. So.
I, as Susan indicated, I don't know that it is, that we need to argue that decision. I think it is worth pointing out that regardless of whether you agree or not agree with the decision, it is a 2008 decision. It's the Valley Advocates decision actually specifically disagreed with the earlier cases, the Monterey jail and the Montgomery ward decisions, and decided and commented it thought that their analysis of the fair argument standard was inconsistent with CEQA, and dicta in those cases is not being necessary. So but I think what is important about the case, whether you agree on it with the ruling or not, is I think it underscores that it can be crucial to have a survey, to have a building somewhere listed. That was what happened in Montgomery ward, where even though it wasn't a formal designation, there was identification of the building as historic. So I think that that's very important to remember. I think it is important to remember that the Valley Advocates case allows a fresh look at whether a building is historic under CEQA. It does apply substantial evidence instead of fair argument, but it it says that they failed to take a fresh look at whether it was historic or not, and it allows a city to be proactive about going out and doing something like Survey LA, where the city is going out and looking. And I think one of the very troubling aspects for property owners is whether there is an obligation to investigate historic resources the way there is other kinds of resources. And I think the Valley Advocates case, although not as clear as might be desired, does suggest there is an obligation to go and investigate, find out whether there are historic characteristics of a building before making a decision on whether it's historic or not. So it may be a split decision on the evidence for historic significance, but it has some other parts of it that I think are very helpful.
And for the agency folks who are listening, I mean, I think you should be aware too, and maybe you are, that League for Protection, 1st District Court of Appeal, Architectural Heritage, 6th District Court of Appeal, both of those were negative declaration cases where EIRs were found to be required based on the fair argument standard. The Valley Advocates, a 5th District case, and it was a categorical exemption case that opined on negative declarations that were not before it. I think this
So,
next part.
so once you have decided whether you're going to have a significant impact, and the significant impact is going to be on an historic resource, the next question, I think, is whether those impacts are clearly mitigated. And I was going to thank Susan for the 2 cases on whether demolition can be mitigated that have now been incorporated into the CEQA law. But I think you've already let the cat out of the bag. That's the Monterey jail case, and of course the Montgomery Ward case. And those cases found that it seems kind of self-evident that demolition of an historic resource has a significant impact on that resource. And there do not appear to be mitigations that would reduce those impacts to insignificance. So I think that it's also very helpful in this context to know what the historic features are, so that you can identify what specifically is being lost through demolition, or what might be able to be preserved through some sort of preservation project. So one of the questions that comes up is not just about demolition, but about what something that's less than demolition. It's an alteration to a building, or possibly an alteration to a site. How do you make a decision on whether that's mitigated or not? And that tends to be very site-specific, and in most cases that I've seen since these 2 leading cases were decided, there needs to be something pretty extraordinary in terms of mitigation, and at least partial retention of a building to qualify as full mitigation.
Well, and I think it comes down to experts too, just like the question of, I don't know if I did that accidentally, just like the question of whether a building is historic or qualifies for register, it has to be an expert. And of course, CEQA doesn't define historic resource experts, so that's within the, that's kind of vague, but still someone with some kind of historic preservation credentials has to opine on whether it's historic. And I would think, on Deborah, and what you were just saying in terms of is mitigation sufficient, that would also require an expert. And if there was a dispute, I think you might have a problem unless there had already been an EIR. I would like to point out that the League for Protection case was the one that said normally You can't mitigate the impacts of a demolition by a plaque or recordation, archival recordation. For some reason, when that got put into guideline form, there's a guideline that says in some circumstances the recordation isn't sufficient, and I don't know why, and I've looked at the files, why it got moved from normally recordation isn't sufficient to in some circumstances, but in fact, that guideline was written specifically in response to the League for Protection case. So those of you that may have wondered how that happened, it is unclear, and I'm hoping they may still change that when they're amending the CEQA guidelines to be more clear.
As I said, my experience is usually that that it's rejected as being full mitigation. Now, one of the other questions that has come up is with projects that take a long time or projects where you agree to mitigation and then decide that it's too expensive or you don't want to do it for some reason, what happens to the mitigation measures? And the Lincoln Place Tenants Association against City of LA, tremendously complicated factual situation with allegations and lawsuits flying in 2005.
With a happy
involved,
ending, though.
Yes, some garden apartments in 1950, built in 1951 in Venice Beach, and the city found that they were. There are a lot of facts that are probably not relevant to this position. The city adopted mitigation measures, including drawings and photos, the things that that Montgomery Ward and Monterey Jail said were not adequate, but nonetheless they adopted those as mitigation measures, and it conditioned the demolition permits on issuing, on complying with those mitigation measures. And the demolition permits were nonetheless issued without the mitigation requirements. That was challenged, and the court said that if there's a mitigation measure, you can't ignore it or withdraw it or get rid of it without redoing your CEQA document. Otherwise, it's a violation of CEQA. And that addressed a question that actually had been somewhat troubling, which is, what do you need to do if you need to change a mitigation measure after the fact? And so we were talking about feasible mitigation measures, and there are, I think every city and every case may be somewhat different in what a feasible mitigation measure may be. It's certainly clear that the courts feel that more than documentation is available. So talking about some of the mitigation measures.
Just one little point is that the Lincoln Place case, one nice takeaway with that quote is related to the fact that there's no time limit on enforcement of mitigation. And it is a kind of a cutting-edge issue right now where we have done CEQA for so many years and there's mitigations and people realize, wait a minute, things weren't really done. There's no time limit on going back to enforce. Because Lincoln Place, it was years later that we came in, and anyway, there was no time limit on that.
Right. So did you want to talk about what an adequate mitigation measure might have been for the old Monterey Jail?
Well, there's no way to mitigate the demolition period. That's in fact because the significant, even though this jail looks really great in these photos, you know, it was full of mold and had all kinds of problems. It looks like it's finally going to get taken care of, by the way. But the county was saying, gee, you know, if the main historic feature is an event, why can't we do an interpretive display in a museum? Why do we need to have the actual physical jail? And anyway, there's no way to mitigate the insignificance, even by doing a wonderful interpretive display based on the criteria of historic preservation.
Well, there's
So,
no requirement that all mitigations mitigate to less than significance if you've done an EIR, and you can do statement of overriding considerations.
well,
So I know that
it comes down to feasibility of what mitigation, but in that situation, you may find you're supposed to adopt mitigation that's feasible, and if you leave out one that's feasible, I think you would arguably have a problem.
right, but interpretive displays, signage,
Well, sure,
later
they're all good.
architecture
Yeah,
are
yeah.
all mitigation measures that, even if they may not avoid all impacts, are typically considered feasible mitigation measures. For archaeological sites, prehistoric resources, these two Madeira Oversight and Bayona Wetlands cases both stand for the proposition that that preservation in place is by statute a preferred mitigation measure, and it must be discussed in the EIR. It doesn't have to be selected, but preservation in place has to be discussed. There has to be a discussion of all the factors, and there needs to be an explanation of why preservation in place is not selected as the appropriate mitigation for archaeological sites. And there was an interesting twist in the Madeira Oversight case in 2011 where the EIR treated the prehistoric sites as historic, but one of the mitigation measures said, and we will send people out afterwards to look again at the sites, and if they decide the sites are not historic, then we don't need to implement these mitigations. So they called it post-certification verification. And the court said, no, once you've decided a resource is archaeologically significant, you can't change your mind afterwards. So we talked a little bit about feasible mitigations and feasible alternatives, and there have been some developments on what makes an alternative feasible. And basically the rule for alternatives is that they have to be able to achieve project objectives. They also have to be sufficiently, when you look at feasibility, you look at whether a reasonable owner would be willing to go forward with the project if it was that alternative. And the objectives themselves have to be reasonable. They can't be so narrow. And in the Preservation Action Council case in City of San Jose, which was the proposal was to demolish IBM Building 25, and you can see the punch card design on the building, which I think is very evocative.
And there's just so you know, this is just one corner. This was like 8 courtyards. This is like just one side of a huge building with all kinds of courtyards with these punch cards all around.
Mm-hmm. So they found the historic demolition would have a significant effect, and they looked at alternatives. They considered a range of alternatives, and they looked at whether they were feasible. And Lowe's, which was the proponent of the project, said they needed to have a 162,000 square foot building, and they would not redesign it. They would not incorporate the portions of the buildings, and therefore the city found a couple of things. They found that the alternatives were not feasible. In the case of a 2-story alternative, they rejected that because it wouldn't, they said, serve Lowe's purposes. But they also rejected a reduced size alternative that could have been built under some of Lowe's rules, requirements, on the basis that Lowe's said they wouldn't do it. And the court said that there were no independent facts that the city had reviewed and identified that showed that Lowe's would have been at a comparative disadvantage. There were no findings to reject the reduced size, and there was no substantial evidence that the reduced size was inadequate. And that needed to be substantial evidence, meaning not just a conclusion that the applicant submitted. Another case that had some slightly different issues was the Uphold Our Heritage against the City of Woodside case involving the Jackling House. And that was sounds like it must have been amazing, 17,000 square foot historic building on 6 acres, had 30 rooms. Steve Jobs bought it in 1984, lived in it for 10 years, rented it to some other people, and then decided not to live in it anymore, allowed it to be vacant, and it rather quickly deteriorated. He applied to demolish the building. He wanted to build a smaller 6,000 foot new home, and he said he didn't want to, it would be too expensive to restore and preserve the Jackling House. And the EIR looked at a number of alternatives, going from less than $1 million to relocate the house to about $9 million for full rehabilitation and additions. Although I don't know why you need an addition for a 30-room house, for additions. And the Planning Commission found that it was not feasible to preserve the house, that it would simply be too expensive. And what the court said was very interesting. They said, we're not talking about how rich Steve Jobs is. Everybody knows he can afford anything. But they said that there was no evidence of what the cost of preservation would be versus the cost of new construction, and that you have to look at the context of that feasibility decision. And the court said that in this case, we don't know whether building a new 6,000 square foot house would cost as much as the preservation, or would be in some other way less feasible. And so they found that comparative evidence is required. And there's a new case.
Well, let me, I'd just like to say a couple more things, but when we'll get to what the new case might say, there's two important points, I think. One is that this case also very much emphasized that you can't get to a statement of overriding considerations until you adequately make findings about the feasibility of alternatives, because the town of Woodside, it's actually the town, wanted to jump ahead. Secondly, in both the preservation action case, that IBM building, and in this Uphold Our Heritage Steve Jobs case, the courts made clear that the desires of the applicant, the preferences of the applicant, Lowe's wanted to build its standard big box store, and Steve Jobs didn't want a historic house that was too big. He wanted a smaller new house. Those aren't part of the feasibility analysis. If the developer's preference could trump all alternatives, there'd be no point to looking at alternatives. So the preferences of the developer are not relevant to the feasibility of a project alternative.
Although it does need to be a reasonable.
Well, of course, there's all other kinds. There's lots of other criteria, but not the developer's preference. The developer says, I don't want to do this alternative, which they always say. That is not evidence of infeasibility. In the preservation action case in the Court of Appeal, they said, well, the city was arguing it was legally infeasible because Lowe's was going to go away if they didn't get to do what they want. So the alternatives were legally infeasible, and the court said no.
In the Flanders Foundation against City of Carmel case, it's a Tudor Revival English cottage. And in that case, the city was proposing to sell the property. They had taken title to it, and I guess found that it was more expensive to maintain than
They'd had it for
wished.
years. They had it for many years.
Right, and
it's in the middle of a park. Mm-hmm.
Right, a 35-acre preserve. They proposed to sell it with 1.25 acres of land attached, and during the comment period, one of the comments that came in was whether it should be on a smaller lot and maybe 3/4 of an acre or half an acre to preserve more parkland, because loss of parkland was considered one of the significant impacts of the sales project. And the court said that should have been, the idea of a smaller parcel should have been considered in the EIR, and it was an alternative that was proposed during the comment period, and if it was feasible and would have avoided impacts, it would need to have been adopted, but in any event, it couldn't simply be ignored. And that goes to the question of needing to address all of the comments in an EIR.
Now we're at 1:17, Jonathan. Do we need to into questions, or do you want us to keep going? What should we do?
I think what I'll suggest at this point is maybe addressing the two questions that we have in already, just in case these people needed to leave early. And then from there we can continue with the presentation and see if there are any further questions. So I'll bring up the first.
Why don't we move to that in a moment, but I just wanted to bring the Sprawled F case that talked about needing to have that comparative information. I think that the economic information, and I think it would be very helpful both for community groups and for public agencies to take a look at that case. It's not an historic preservation case, but it really says that comparing the impact of the alternatives and the project, the financial feasibility, is even more important than the exact dollars. And you need to make that comparison part of the analysis. So let's move on to questions.
Okay, so there are currently two questions that came in. The first one is, can you explain fair argument a bit more, and does it have to do with the merits of a case?
Well, I can jump on that one. It's a very handy, kind of colorful analogy there. Whit Manley, who I teach a lot with, who's a development side lawyer, he describes the fair argument standard, the burden of meeting the fair argument, as akin to jumping over a garden hose. It's a really, really low threshold because CEQA, the legislature has clearly legislated EIRs as the preferred method of environmental review. So they make it very easy to trigger an EIR, and the fair argument standards, the opposite of what usually happens with a public agency decision. Usually a public agency, the elected officials have a lot of discretion. If there's any basis for their decisions, they are upheld. The opposite with a fair argument standard, if an environmental petitioner or a neighbor or someone who is trying to promote an EIR, any credible evidence that they present that a project may have a significant impact is sufficient. They have to have substantial evidence, which are facts, reasonable assumptions predicated on facts, or expert opinion based on facts. But if they have any one of those, it doesn't matter how much evidence is against them. The agency can't weigh the evidence. As Deborah said, if you had a scale, you would just look at one side of it. You're not balancing. If there's any credible evidence that a project may have a significant impact, sufficient to raise a fair argument, then an EIR is required. That's the only time the fair argument standard is used. It's when the question is, do you need an EIR to be prepared for a project?
And the city doesn't get to decide, we don't think it's credible if it is credible. In other words, after an EIR is prepared, the city can look at information from two experts and decide which one they want. At the pre-EIR stage, they don't decide which one they want. It's if there is anything on that side of the scale. So it is a very very low standard.
And there's a guideline that says a dispute among experts. That's 15064 says a dispute among experts triggers an EIR.
Okay, great, thank you. And the second question is in regards to archaeological sites. I know you mentioned one case, brought up one, but I think the question is if you can think of any other cases or if it comes up a lot with CEQA.
Well, there were two cases. The Madeira oversight was archaeological, and the Bayona wetlands case was archaeological sites where they actually had removed the resources. But they still needed to go back and redo their EIR to look at preservation in place. I think there are some other cases, and we
Clover Valley. Isn't there a Clover Valley Foundation case?
I think the guideline in the CEQA and the guidelines have pretty extensive discussions themselves of archaeological resources, and it's pretty helpful to take a look at the guidelines.
There used to be extensive archaeological guidelines that were different from historic preservation guidelines. There's a little bit now, but much, much less than there used to be. So all of the historic cases apply also to archaeological cases. Archaeological resources are almost always historical resources. So the same case law and guidelines do apply and there are a few special ones. And this mitigation in place or preservation in place is the main thing that the cases have looked at, that is a preference, although not required, if it's infeasible to preserve in place.
Great. I also will mention that our next webinar on the 15th of July will have an archaeologist on the panel who will cover mitigation as it relates to archaeology. And we do have a few other questions come in. Are you two okay with addressing these two extra questions before continuing?
Sure.
Okay.
Yeah, of course. We can.
One you can probably see in the chat box. Yeah, and it says, in light of the new CEQA infill streamlining, what are the best strategies for making sure a new specific plan protects historic resources?
I don't know if you have a thought on that, Deborah, in terms of a strategy.
Well, I think one of the strategies, because you need to be consistent in order to take advantage of the infill streamlining, you need to be consistent with the specific plan, is to ensure that the specific plan recognizes the resources and requires the level of preservation that is that the city wants and can justify, so that if there is a proposal to come in and demolish or substantially alter historic resources, it would from the get-go be inconsistent with the specific plan.
And that they also, some of the, as I recall, the new guidelines about infill and about transit, the exemptions for projects that are in a transit priority zone, they did add some exceptions for projects that may affect historic resources. So we did get some built-in, protections in that guideline.
They clarified that historic resources are not aesthetic resources, because they were going to prevent challenges to aesthetic impacts. Right. And so it was clarified that that historic resources have a different basis than just how the buildings look.
Great. And then the second question is, if a city is going to issue a S of OC for a substantial negative impact, how do you go about providing evidence that, one, the developer has not sufficiently looked at the feasibility of a recommended alternative with less impacts, and two, the mitigation efforts proposed, in, including HAB's documentation, are not enough to mitigate the demolition of the building?
Well, first of all, the statement of overriding there are two findings required when a project's approved that might involve impacts to significant impacts or demolition of an historic resource. So there's two findings. One is that there are, there's no feasible alternative, and, feasible is kind of a wiggle word, but anyway, that it's not feasible. There's no feasible alternative to avoid the demolition. And only when you've found that there aren't feasible alternatives can you then say, well, this project's going to have a significant impact. In that situation, we can only approve it with a statement of overriding public benefit. So a lot of agencies and advocates think that as long as you can get the statement of overriding considerations, that the politics are there, you don't need to worry about first proving that there are no feasible alternatives. But the Uphold Our Heritage case that's cited in this, in the PowerPoint that we've been talking about, the Steve Jobs case, is a really good one to look at for that you can't jump to a statement of override, that you first have to show that it's infeasible to do an adaptive reuse project. And the Architectural Heritage case and the League for Protection case, both of those help you, and the Uphold Our Heritage case as well, help in showing that recordation and the normal mitigations for loss of an historic building, even though they're better than nothing, the cases are really clear that they do not they normally cannot reduce impacts to insignificant, because it doesn't take away the loss of the building, right? That's why we said that thing about the chalk marker rather than dead body. The dead body isn't back. So you can record where it was, but clearly it's still gone. So it's really a fairly straightforward argument that is supported by the case law, that when you've lost the resource, you're trying to do what you can to mitigate, but there's no way to say that you've mitigated it to a level of insignificance unless in a really rare circumstance where there really wasn't much there anyway, maybe.
I think the statement of overriding considerations has gone through a lot of different permutations over the years, and the statement of overriding considerations is really a policy statement that says, even though there's going to be this impact that cannot be mitigated. So Susan's right, you have to find it cannot be mitigated, or fully mitigated. We're still going to, there are other overriding considerations, whether they're economics or jobs or housing, that is going to make us accept these environmental consequences. So you don't cure a problem with the EIR by having a really good statement of overriding considerations. As a matter of fact, although it's very typical to want to have good evidence to support the overriding considerations in the record, a court can't say, I disagree, that's not an important enough policy to override it. That's the policy part of the decision. But it doesn't fix an inadequate EIR at all. And so I think Susan's right in pointing out that it's a multi-step process, and the statement of overriding consideration is at the very end after the EIR process is essentially completed.
And after there's been a determination that it's not feasible to retain the building or adaptively reuse it. I completely agree with Deborah.
Okay, I mean, at this point, we did have a few more questions come in, so it's really up to the two of you whether you want to devote the rest of the time to finishing up your presentation or addressing questions.
Well, I think we should address questions since
I
we
agree.
got through the, yeah, okay.
Okay,
We
so we have
actually,
one in the
believe it or
chat
not,
box right now.
we managed to sneak in
Yeah.
most of
Right.
the remaining information out of order. Now, I've lost my screen. Is that
Oh,
because
can,
it's after
yeah.
1:30? Okay, so
it's
Jonathan, we'll rely on you for questions.
absolutely, and I'll verbalize them right now. So, coming from Shanna, would you comment on recent case law regarding indirect impacts to historic resources? Specifically, I'm interested in case law or precedent regarding setting, feeling, historic districts. It's clear that the issues driving the analysis should revolve around the scale, massing, and design of the new adjacent construction. What is not as clear is where the tipping point should be between new adjacent construction that is compatible versus new construction that adversely impacts setting to the point that the historic district loses integrity. So I'm wondering if you could address that.
I can, there isn't case law on that yet, I don't think, but not that I'm aware of. The Berkeley Hillside case that we have at the Supreme Court now does involve, as I mentioned, impacts to a neighborhood that's a historic and architecturally significant neighborhood, and so there's an issue of inconsistency with those general plan policies, but that's not exactly, I think, your question. The CEQA guidelines basically define significant impact as including the impacts to the resource or its surroundings that affect the integrity of the historic significance and the integrity of the resource. I have on many cases made arguments about context and surroundings, et cetera, but in terms of legal precedent and case law, we've barely been able to, in the courts, be understood about demolitions and losses of buildings being significant, much less trying to have a court understand about the significance of the context and surroundings. But I think the legal, the statutory and guideline authority is there, but I think, as in most things with CEQA, you just have to make the best case you can. If an agency wants to protect a resource because it feels the context and the integrity is going to be impacted by something happening adjacent, just need to document that with experts. We talk about cultural landscapes now, which seems to be a more broad concept than just losing a building, and that's something else that could be documented. But I think, as in most of these situations, you need an expert to say there's a significant impact and an expert to explain how the context and the surroundings of a resource, are integral and important, and make your argument from there.
I'd also comment, it may be worth looking for some NEPA precedent, the National Environmental Policy Act. I know that at least a while ago, the lead on that had to do with approving, I think it was a road in an area that was going to bring more visitors to a that would be adjacent to a very fragile Native American site. And there are precedents from road construction with transportation. And there are a couple of different ways to, one is if you have a district, and a lot of times you'll have guidelines for new construction in a district, so you can consider the new construction according to the guidelines, and the guidelines might themselves be a CEQA mitigation. For individual structures, I haven't seen very much, although there was apparently a fight constructing the Madame Tussauds in Hollywood and the potential impacts on the Chinese theater, and used a lot of the kind of typical things you look at if you're coming in to get a proposal for a new building. Is it out of scale? Is it going to have lighting impact? Is it going to be shadow? There is precedent for how you look at whether a building considers or is respectful of surroundings, not necessarily in the historic context, but can certainly be used to
Did we lose you, Deborah? I still see you down there.
You lost me for a second. I'm here, Susan. Sorry about that.
Oh, okay.
Oh, shoot, I don't know what happened.
Okay, maybe while we're waiting for her to get back, we would follow up with the final question. And since we're beyond our time, this would be the last question. And I'm more than welcome, or more than happy to email. If anybody would like to email me questions, I can forward them to Susan and Deborah, or you can email them directly. But the final question is, would you please talk about economic feasibility and its relation to CEQA law?
Well, the definition of feasible, when you're looking at alternatives, is capable of being accomplished in a reasonable amount of time, taking into account economic, social, I don't know all the lists, but it's social, technological, and other factors. But economic is the first one. And when it comes to historic preservation and adaptive reuse, which I think is really the better those are the real words that we're talking about, is adaptive reuse. It often comes down to economics. In the Preservation Action Council case, that IBM case, the court was really clear that, any economic statements by the project applicant that the alternatives are economically infeasible maybe we got Deborah back. Oh, maybe not. Need to be independently analyzed by the lead agency. So there's that. You can't just have a letter from the applicant saying this is going to cost us too much or it's not going to be feasible for our business plan. Often there's proprietary information, et cetera, but if often developers don't want to rely on economics, they don't want to disclose their numbers, but there needs to be some evidence to show that something really is economically infeasible. There are a few cases that now say economic feasibility does not need to be in an EIR. That's a highly debatable point, but there is a guideline that says economic analysis does not need to be in an EIR. But when you look at the derivation for that guideline, there's no statutory authority for that, and it used to be. I think it came in because what I've understood is that initially people didn't want CEQA analysis to have a lot of information about the importance of making money in the tax base, and they didn't want a lot of talk about economics clouding what really was supposed to be look at environmental issues. But anyway, there was a footnote in a case that then led to reliance on another case, by another case. I think it's in this PowerPoint under the San Franciscans upholding the downtown plan case, said that economic analysis does not need to be in the EIR. It needs to be somewhere else in the record. Again, that's debatable. Not all the districts have weighed in on that. The Court of Appeal and most public agencies do include economic analysis. It is helpful to the decision makers. There's no reason not to include it if the agency wants to, and it does make sense. I would suggest as a way to help the decision maker, the elected officials, make decisions. Why not have the economics subject to the public process? So I don't know if that answers the question, but it certainly is an issue. It almost always comes down to economics with the feasibility of adaptive reuse of historic buildings, and there needs to be evidence in the record if they're relying on economic factors to say something isn't feasible.
Okay, great. Thank you very much, Susan. And we are about 10 minutes over time, so I'm going to close it off right here. I wanted to thank both of our speakers. If Deborah can hear me, thank you very much, Deborah. If not, I also wanted to thank Susan. Both have been wonderful supporters of California Preservation Foundation for a long time. And from here, I'm actually going to close out the session, but I also, if anybody has a few extra minutes, I would appreciate people filling our survey and letting us know what you'd like to see in the program, any comments. Once you complete the multiple response options, please scroll back to the top of the page and click Submit Response. Otherwise, we won't receive it. There are some related links at the top of the page. As we mentioned earlier, the CEQA series, the final part of the CEQA series will close on the 15th of July with a roundtable discussion on mitigation. If you need to sign in, there's a link to the sign-in sheet, and you can also view all upcoming events on the California Preservation calendar of events. We also appreciate any written responses you'd like to give on this session. To the right of the screen are the written responses, so please leave feedback, and we appreciate your time today and your support of CPF. And thank you, Susan and Deborah. Have a great day.
Thank you.